My name is Tony Varona. I'm on the faculty of the American University Washington College of Law. And before we start, I just thought that I would say, as I always say after I follow Paul, that we were so lucky to have had Paul Smith argue Lawrence for us before the Supreme Court. And every time I hear Paul speak, I just well up with that feeling. You know, Paul said that he was certain that a lot of people in the room wondered who he was, since, he was relatively new to gay civil rights litigation at that time. And I shared with him afterward that I had the funny experience of having received a phone call from one of my friends from practice, one of my colleagues, soon after Paul argued so brilliantly. And this guy called me up and said, "Do you know this guy Paul Smith?" And I said, "Well, I've met Paul now and, a couple of times. Isn't he brilliant? Well, isn't that just fantastic?" And this guy said, "Well, but I wanted to call you to see if you had a boyfriend, because he's so handsome." Anyway, I promptly said, "We are not having this conversation right now." Many, many thanks to Emory Law School, Liz Seaton, Judy O'Kelly, everyone else who made possible this fantastic conference. The title of our panel is a very good one, in that it describes precisely what it is that we will be doing for the next 90 minutes. Looking back at Lawrence versus Texas on decision day and over the past 5 years. What was the true significance of Lawrence on June 26, 2003, and how has it affected our lives, LGBT law, our legal system generally, and our nation as a whole? In reacting to the decision on the day it was handed down, some commentators characterized it as a much-needed self-correction by a court that had gotten it so terribly wrong 17 years earlier in Bowers versus Hardwick. But many of these commentators who celebrated the decision characterized it as a modest one, some pointing to the fact that many of the sodomy laws in effect in 1986, when Bowers was handed down, had since been struck down or repealed, including most notably the Georgia sodomy law at issue in Bowers. That law was struck down as unconstitutional by the Georgia Supreme Court in 1998 in the case of Powell versus State. Others saw Lawrence as an especially egregious instance of ultra-vires judicial activism. In his dissent, Paul referred to some of it, Justice Scalia famously fulminated against how the majority had effectuated, quote, "a massive disruption of the current social order," unquote. He wrote, quote, "Today's opinion is the product of a court which is the product of a law professor and culture that has largely signed on to the so-called homosexual agenda," unquote. An agenda that goes against how, quote, "many Americans do not want persons who openly engage in homosexual conduct as partners in their businesses, as scoutmasters for their children, as teachers in their children's schools, or as boarders in their homes," unquote. In response to the majority statement that its decision does not implicate same-sex relationship recognition, Justice Scalia retorted, "Do not believe it," going on to vituperate that, quote, "Today's opinion dismantles the structure of constitutional law that has permitted a distinction to be made between heterosexual and homosexual unions," unquote. Now, I witnessed this split in immediate reaction firsthand to some extent. I heard the news of the court's decision as I was driving from an HRC board meeting in D.C. back to New York, where I, at the time, was on the faculty of the Pace Law School. And like many of you, I was elated by the news. But because I was on that stretch of the New Jersey Turnpike, where you can pick up only a couple of conservative talk radio stations out of Philly and a couple of weak college stations from South Jersey, I sat and listened to Rush Limbaugh react to the decision. And as you can imagine, he was beside himself. quote, "This Supreme Court," oh, this isn't quite a direct quote, but "this Supreme Court is out of control. This decision is nothing but an act of social engineering that will put us on a slippery slope toward homosexual marriage," etc. You can just hear it, right? What was most interesting to me, though, was not Limbaugh's bloviating, but that when Rush finally went to callers, every single ditto head, which is what he calls his callers, disagreed with Rush. Disagreed vehemently, in fact, saying, "Rush, I usually agree with you, but I actually disagree with you now. I agree with the court. Why should it be a crime for two consenting adults to have sex in private?" The state, one caller actually said, "The state should stay out of our bedrooms." I remember that line in particular quite well. After about 4 or 5 of those calls, Rush started to yell at his call screener, so I tuned away. But that example really does exemplify how the decision was greeted with a starkly split reaction across the nation as a whole, but even within the civil rights and specifically LGBT community itself. We all had immediate questions, like if there was just a handful of sodomy statutes left on the books anyway, and most Americans thought the sodomy laws were silly, and the court had been so shamed from far and wide for its decision in Bowers, then how significant and monumental of a decision was Lawrence? Some asked. And what exactly did Kennedy's majority opinion do? This is a question that Paul just answered for us, I thought, quite well. Did it reify an especially toothy version of rational basis review, or did it introduce in an admittedly subtle way a heightened scrutiny? Did Lawrence articulate a fundamental right to autonomy in decisions about private, intimate sexual conduct? Did it do so clearly? If it didn't do that at all, then what did it do? Was it the sort of broad and sweeping decision that many celebrated the day it was decided, or was it merely a modest, narrow, chastened correction of Bowers and nothing more? And besides asking what the court actually did on June 26, 2003, we need to look back and see how the Lawrence decision ramified across LGBT civil rights law through the last 5 years. What has its effect been on the struggle for same-sex marriage? Was Justice Scalia right in arguing that the majority's disclaimers notwithstanding, the Lawrence decision, in fact, did open the door to same-sex marriage? Or was its effect on the marriage battle less doctrinal and more atmospheric, contributing to a popular and political backlash that culminated in so many state anti-gay marriage amendments, and some would say, some have said, the re-election of President George W. Bush? Thinking more broadly, although Lawrence was a seminal decision in LGBT law, how has Lawrence's teachings affected other areas of law? Has it proved useful in the fight for women's reproductive rights, or in the struggle for racial and gender justice more generally? Suffice it to say that Lawrence versus Texas in its first 5 years have generated more questions, perhaps, than they've answered. And we have a truly top-drawer panel of speakers to help us answer those questions and perhaps frame new ones that we can take with us into the next 5 years and perhaps answer at the 10th anniversary celebration of Lawrence. In alphabetical order, our speakers are these. Dale Carpenter is the Earl R. Larson Professor of Civil Rights and Civil Liberties Law at the University of Minnesota Law School. He teaches and writes in the areas of constitutional law, the First Amendment, sexual orientation in the law, and commercial law. A former clerk for Judge Edith Jones on the Fifth Circuit Court of Appeals, Professor Carpenter practiced at Vinson and Elkins in Houston and at Howard Rice in San Francisco. He holds a J.D. from the University of Chicago Law School, where he served as the editor-in-chief of the Chicago Law Review. Nan Hunter is a professor of law at Georgetown University Law Center, having joined Georgetown's faculty after a long tenure at Brooklyn Law School. She teaches procedure, health law, and sexuality and gender in the law. In fact, Nan, with Bill Eskridge from Yale, wrote the book on sexuality, gender, and the law that is known by that very title, and that I've used to great effect in my own courses. Professor Hunter not only is a nationally celebrated scholar, she also served as Deputy General Counsel of the U.S. Department of Health and Human Services from 1993 to 1996, and served on the President's Advisory Commission on Consumer Protection and Quality in the Healthcare Industry. Professor Hunter's law degree is from Georgetown. Susan Sommer is senior counsel at Lambda Legal in New York. Susan is the director of Lambda Legal's Foster Care Project, which aims to ensure that LGBT youth in foster care are safe and have the support and resources they need. She leads a historic joint partnership between Lambda and the Child Welfare League of America, making LGBT youth a clear priority for state and local children's agencies around the country. She served as the lead attorney on Lambda's lawsuit that convinced the Arkansas Supreme Court to strike down the state's anti-gay sodomy law and clearly identify a right to privacy in the state's constitution for the first time. Susan also played a key role in the Lawrence litigation, as noted by Paul just a few minutes ago. Susan graduated from Yale Law School. William B. Turner is visiting assistant professor here at Emory Law School. Professor Turner teaches a practice-oriented course in LGBT issues and American legal history, among other subjects. Bill came to Emory in 2006 as a visiting scholar in the Feminism and Legal Theory Project. Professor Turner's scholarship centers around racial and sexual orientation discrimination. He is very widely published, but perhaps is best known for his co-editing with John D'Amelio and Urvashi Vaz of Creating Change, Sexuality, Public Policy, and Civil Rights, in which he wrote a chapter on lesbian and gay rights in the Carter and Reagan administrations. A short chapter, Bill, perhaps?
Yeah, I can write short chapters.
Professor Turner holds a JD from the University of Wisconsin and a PhD in history from Vanderbilt. Now, I have asked each of our panelists to begin with a 5 to 7 minute introductory statement focused generally on the question of what the last 5 years have shown us about the ways in which Lawrence has been a success and the ways in which Lawrence has been a failure. I want us to get quickly to the nub of how Lawrence has been most impactful within the last 5 years, and then we'll follow up with some interpanelist dialogue for about 30 minutes, and then hopefully open up to a very lively discussion with all of you. So, Susan, would you like to get us started?
Sure. Well, it's a great honor to be here and to have been like the backup singer to Paul's rock star performance. Unlike my academic colleagues, I am sort of a slogging litigator left with the wonderful decision of Lawrence, but trying to apply it and live up to its ideals and also the things that were said about it the time of the decision. I'm taking my lead from the title of our panel today, which is looking back at Lawrence on decision day and over the past 5 years, and I'd like to just place us in time about 5 years ago, and leading into the Lawrence case, I had just worked on the Arkansas sodomy law challenge, which did not involve an arrest of individuals engaged in private conduct, but was a challenge on behalf of a bunch of Arkansas residents who didn't want this law hanging over their heads, criminalizing, giving them a criminal status and stigmatizing them. And so standing was a big issue in the case, and I spent a lot of time leading into the Lawrence experience, really delving into the lives of these individuals so that we could demonstrate to the court why it mattered and they should be allowed to proceed with their suit. And there was a stunning amount of experiences in which the fact that the state decreed them criminal had come back to really hit them in the face, sadly in some cases quite literally. For example, one of the plaintiffs had been attacked by an anti-gay mob who literally used epithets, you're a criminal, you break the law, and after this assault, he was afraid to report it to the police, again, because he felt labeled as a criminal in his state, and to report an anti-gay attack was to confess that he was part of a stigmatized class. So, fast forwarding a few months to the day of the Lawrence decision, it was an amazing day. Most salient thing I think to remember is that we won, and we won really big. However, the last 5 years may have played out in how the decision has actually been applied in other contexts. But Bowers was decisively overruled. The court's language really went beyond, I think, erasing a precedent, but really erasing a stain. And looking at what was said by the press, by Lambda, by others that day and the days that followed, I think helps also to place us at that moment in time. New York Times reported that the Supreme Court had effectively apologized for Bowers and how it had demeaned gay men and women. Newsweek spoke of the far reach of the court decision, that gays were entitled to a right to privacy. I've often felt like I wish I could just cite Newsweek as an authority in future cases. Professor David Garrow said it may be one of the two most important decisions of the last 100 years. What we said at Lambda that day after we stopped our weeping and pulled ourselves together was a lot of, I will admit, a lot of sentiments of pride and celebration, and also a lot of generalizing, because, like many of you, we also recognized that we needed some time to digest fully the richness of the opinion and also some of its silences. We spoke of it as a beacon of light, as representing a sea change, as opening a new chapter in the rights of gay people. These are fits almost any kind of situation, those kinds of words. But we were really, I think, transfixed and incredibly proud, and felt an enormous amount of possibility in these words of this use of terms like dignity, liberty, respect, tying the struggle to the historic train of democracy, to the search for greater freedom, for freedom from oppression. The way the decision wove together guarantees of equality and liberty, and the way the decision built off Romer versus Evans's important rejection of moral condemnation alone as a basis to discriminate. Our right-wing enemies also had much to say. And one of my favorite quotes is of Jay Sekulow, the Conservative American Center for Law and Justice director. He's not usually my go-to guy, but he said right after the decision, we all were especially surprised by the scope and breadth of today's opinion. It was a grand slam homer for the other side. Or was it? And I think that's part of what we're here to discuss today. I mean, it has incredible features, that opinion and that decision, and something that I think I will always be proud of having played some role in. But it does have features that have come to bedevil LGBT civil rights litigators. And, for those who are actually involved in litigating the cases, in some ways, one wishes that the court could have gone even further, although it feels so greedy to ask for anything more. The court, of course, didn't spell out, italicized, put in boldface words like, we proclaim today that the right at stake is a fundamental right, infringements of which are subject to strict scrutiny. And others on this panel and many other scholars have pointed out that that in their view, the decision reflects more of a placing liberty interests on a spectrum and allowing for a sort of more organic balancing, less tiered approach. The problem is going into court as a litigator and trying to explain that to judges who are very reluctant, first of all, often to do anything for gay people. Certainly not if it requires pushing legal doctrine beyond what they can, beyond something that's highlighted, bolded, italicized for them. And also when it involves constitutional law, so it becomes kind of written in stone and becomes, a legislature can't come back and say, no, that's not what we meant. And so unless you're really in the U.S. Supreme Court, it's been an incredible challenge in many contexts to make the courts understand the true richness of the Lawrence decision and not see some of the meaning drained away. Another thing that was said that day, I remember saying in one of the, little things, one of the speaking moments I had, microphones thrust in my mouth, in my face, was that that one thing was sure, that Lawrence decision would spawn a cottage industry of academic research and discourse. And there I am right. I was right. How prescient of me. I mean, today I think helps to bear that out. I just did a little look-see on Westlaw, and a whopping 2,700 law journal articles have cited the Lawrence decision, ranging from the incredibly thoughtful scholarship of, for example, Manhunter and others here today, to mine Lawrence's meaning, to place it in its position in the jurisprudential history and civil rights history, to maybe my personal favorite title out there, which is a 2005 Albany Law Journal article called "The Bald and Golden Eagle Protection Act." So there is something in Lawrence for almost everyone. But going back again to the day of the decision, I was asked by a relative who called me up, actually my brother, to congratulate me, and he said to me, "Does this now mean you're out of a job? I mean, does Lambda get to close up shop? Is the work's over? You're done?" And of course, sadly, in many ways for LGBT people, although it's been a wonderful journey for me, the answer is no. We still have enormous work cut out for us. Lawrence wasn't clearly it wasn't the magic bullet, but it was an incredibly important weapon in the arsenal. But I do think that it has brought us much closer to the day when we may really have to find something else to talk about. So I leave it to.
Great. Thank you so much, Susan. Dale, would you like to go?
Sure. Well, I just would echo what was just said. Thanks for inviting me. I really am pleased to be here with others who have written so much and so well about this decision about gay rights, and especially I'm always interested in hearing what Paul Smith has to say. He's always very eloquent and interesting. I'm actually writing a book about Lawrence versus Texas, and the factual background of the case and the development of some of the legal arguments in the case. And Paul was generous enough to give me a huge amount of his time. He's a very busy lawyer. And I can tell you from having spent those several hours with him one night in New York about a year ago, and having spent considerable time with some of the other lawyers who worked on both sides of this case, that one of the huge advantages that the pro-gay rights side enjoyed in Lawrence versus Texas was in quality of advocacy. I think the New York Times, the morning after the oral argument in Lawrence versus Texas, said that it was had been a mismatch rarely seen in the history of the Supreme Court, and that was certainly true. I was there, and I know a number of others of us were there. But that mismatch was really present, I think, throughout the litigation. Lambda did an extraordinary job of putting together a team of lawyers to produce this decision. And it was a huge accomplishment. It ended, of course, the Texas sodomy law. It ended all sodomy laws across the country. And if it did nothing else, that was a momentous result. It meant that the presumptive criminal status of gay people in the United States was now over. And that meant something not just for those gay people who lived in the remaining 13 states with sodomy laws at the time, but it clearly meant something symbolically, at least, for gay people around the United States. Paul mentioned the raising of the American flag in the heart of the Castro on the day that the decision came down. That's not because Californians had been suddenly freed to commit sodomy in the state, but it's because the decision spoke to their hopes and aspirations in a way that the Supreme Court really had not done before, quite so powerfully. And it meant that a half-century-long project of ending sodomy laws in this country had now been brought to a successful conclusion. Nevertheless, and you knew this was coming, 5 years on, I think it has to be said that Lawrence has been a disappointment. It has had relatively little generative force for gay equality beyond its immediate holding. So let's look back on what we might have expected in the summer of 2003. There was a lot of hope, as has been mentioned, that Lawrence would provide the basis for tremendous advances in litigation for gay rights, because it was, nothing else was clear about the decision. It was clear that the court had done at least three things. First of all, it had revived in what looked like a fairly dramatic way the doctrine of substantive due process, which was a doctrine that had looked like it had reached a dead end in cases like Bowers versus Hardwick and in Washington versus Glucksberg. It had become the captive of old, musty traditions, and traditions as understood by the court and by the lower courts that were not favorable to the equality of gay Americans. The second thing that it had done is that it had defined the right involved in the case in a quite broad fashion as being about something like adult, private, intimate choices, and not as a right of homosexual sodomy. And third, the court talked repeatedly about respecting relationships, not just about sex, which suggested that Lawrence might have some kind of application beyond physical acts, even though the court had disclaimed any intention to recognize formally gay relationships in the law. But there was a problem with the opinion from the outset, and that was its opacity. It was full of talk about transcendent dimensions and autonomy of self. And much of the opinion, even beyond that, the meatier parts of the opinion, was really devoted to unpacking the history of sodomy laws in the United States in order to refute some of the claims that had been made in Bowers versus Hardwick in the majority and the concurring opinions. And while that was interesting as a matter of history and needed to be done, it wasn't enough by itself to get us much farther. The opinion contained little conventional constitutional analysis. The standard substantive due process framework for analyzing infringements on rights was entirely missing. There was no explicit reference of any kind in the court's opinion to the question of whether the court thought it was dealing with a fundamental right, no explicit reference to the level of scrutiny the court was applying to infringements on that right. And so in a sense, the opinion was a lot of sound and fury, and we were left wondering, what did it signify? Well, into an interpretive vacuum immediately poured a number of different theories about the case. And I can't mention them all, but let me mention what I think were three prominent strains that summer and fall of 2003 that came out. One interpretation of the opinion is that it was a standard fundamental rights opinion. This was certainly Paul Smith's view of the case. It was my view of the case. It was Lawrence Tribe's view of the case. Michael Dorf's, many other scholars viewed it that way. A second view, interpretation of the opinion, is that it was really a rejection of the old model of substantive due process, with a neat bifurcation of rights into fundamental rights on the one hand, which get some kind of heightened scrutiny, and liberty interests on the other, which get not much scrutiny at all. And instead, some authors suggested that that old bifurcation had been replaced with something else. What that something else wasn't entirely clear. There wasn't much agreement on it. But a couple of strands of this view emerged. One of them was that the court was replacing the strict tiers of scrutiny with something like a sliding scale, which was just mentioned. A different view suggested, this was a view expressed by Randy Barnett, that the opinion was a fundamentally and deeply libertarian opinion, and that it meant that any time the government infringed on any kind of liberty interest, it would have the burden of proof, and that would go not just for sexual intimacy, but all kinds of other rights that libertarians might want to claim in courts. Then there was a third view. The third view is, or was, that the opinion was nothing more than a rational basis opinion. It was Justice Scalia's view of the decision. That is, that the court had not declared the existence of a fundamental right, that it had applied rational basis to the Texas sodomy law, and that gay sex was a mere liberty interest subject to that rational basis, And in the Scalia view, the only real impact of the opinion was that an unadorned moral justification for a law on rational basis review would no longer be sufficient for that law to survive constitutional scrutiny. And while Justice Scalia certainly thought that was a major development in constitutional law because it would lead to the elimination of laws against things like bigamy and obscenity, and he even mentioned at one point masturbation, it really wasn't that big a deal, because under standard rational basis review, at least, almost every law could be justified by some conceivable harm-based justification. Very few laws were defended in court with this sort of unadorned moral interest of the people of a state. And so when you put together the usual extremely deferential rational basis review approach with that view of Lawrence versus Texas, almost nothing beyond sodomy laws would ultimately be affected. And as one of my constitutional law professors has put it, rational basis review basically means that a law is constitutional if any fool can come up with a stupid reason for a bad law. And the federal courts are amazingly well equipped to do that. Now, since 2003, we, I think, can make some judgment about which of these three interpretations has emerged as the victor. What does the landscape look like? Who is winning the battle for the meaning of Lawrence versus Texas? Well, I think it's clear, looking at the decisions since then, that the third view is the winner. In fact, Justice Scalia's view of Lawrence is the one that has so far prevailed. This is one of those occasions, in fact, I'm struggling to find another, in which a dissenting opinion, a dissenting interpretation of a majority opinion is, in fact, the controlling opinion that comes out of the case. And all of the bad aspects of the dissenting opinion from a gay rights perspective, and none of the good ones. Think, for example, about some of the cases that have been decided since Lawrence versus Texas. Paul mentioned, for example, Lofton, which the 11th Circuit upheld a truly onerous law from Florida preventing practicing homosexuals from adopting children. The court in that case said Lawrence was no barrier to the decision, in part because Lawrence was nothing more than a rational basis decision. We even have a circuit split now on the question of whether state laws against sex toys are constitutional, with the 11th Circuit saying that they are, and the 5th Circuit saying that they're not. And even the 5th Circuit says that Lawrence versus Texas is a rational basis case. The one, I think, clear victory since Lawrence versus Texas was a case that was being decided just about the same time, Lyman versus Kansas, where the state court ultimately, having been brought to this kicking and screaming, relied on Lawrence to strike down a state law that imposed much greater penalties on sex between underage teenagers when they were of the same sex than when they were of the opposite sex. But even in that case, as I recall, the court read Lawrence as being nothing more than a rational basis case. Even on the question of marriage, this is the one thing that Justice Scalia had warned Lawrence might bring about, a dismantling of the constitutional structure or edifice related to the marriage laws around the country. What has been the result? I don't think the court's opinion is being read by the state courts across the country to strike down the marriage laws. With the exception of the Massachusetts Supreme Court in Goodridge, all of the state high courts that have looked at state constitutional claims for marriage have struck them down. And I would suggest that even in the Goodridge opinion, which did cite Lawrence versus Texas a couple of times, the citations were not for any important substantive point that the court could not have made without the Lawrence decision. They were a kind of rhetorical embellishment to add to a decision that would have been reached even without Lawrence versus Texas. So I think it's worth actually asking 5 years after Lawrence versus Texas, and I mean this only partly as rhetoric or provocation, would Lawrence itself be decided the same way under Lawrence versus Texas? I'm not entirely sure that it would be, since a state can usually come up, as we've said, with some kind of bad justification or stupid justification for a bad law. And in fact, in the Lawrence case and in other cases, states have come up with incredibly bad justifications that ordinarily have withstood rational basis review. Now, I'm not saying that the limited impact of Lawrence is necessarily and in every way a bad thing from a gay rights perspective. I think that to a very large extent, the future of gay rights in the country, whether it's in ending marriage or bringing marriage or ending the military ban, is going to depend, as a practical matter, much more on making progress with the public and in legislatures than in making progress in courts. And so perhaps we should be content with what Lawrence did, because it did a lot in itself, and move on from there.
Thank you very much, Dale. Nan.
Okay, great. Thank you very much. Thank you for inviting me. It's a real pleasure to be here. And I have to say, I'm so happy I get to follow Dale, because I'm going to sound like an optimist compared to Dale. I want to talk a bit about positioning Lawrence in context other than law, and then speak a bit to where I think Lawrence positions the law, and then make some comments about the sort of contest over the meaning of Lawrence, which is, I'm sure if there was anyone here who did not already know, you have figured out that the last 5 years has been a contest reenacted many times in many courts over what Lawrence means. So first, a couple of words about the politics and the culture. I think it's important to remember that politically Lawrence came at a moment when, following the move to state courts out of federal court that followed the loss in the Supreme Court in the Georgia case, Bowers versus Hardwick. And as I hope everyone here knows, at least everyone who's a law student or a lawyer, the Georgia law that the Supreme Court upheld based on the presumed opinion of Georgians about the immorality of homosexuality was later struck down by the Georgia State Supreme Court, which was one of the earliest of several embarrassing moments for the U.S. Supreme Court, in the sense that state Supreme Courts in a number of conservative states, including the case that Susan won in Arkansas, struck down their own state statutes. And this had a very powerful effect, I think, politically as well as legally. Legally, of course, it just affected each particular state. But politically, it showed that there was traction for an argument for securing fundamental precepts of liberty, at least from state intervention, across the United States. So that when Hardwick was argued, the case that we lost from Georgia, the breakdown was basically half and half. About half the states had sodomy laws, and about half the states had already repealed their sodomy laws. By the time the case of Lawrence went to the U.S. Supreme Court, there were as many states that had anti-discrimination laws as there were states that had laws against sodomy. And so the breakdown then was 13 states still had sodomy laws, 13 states had anti-discrimination laws protecting LGBT people, and the rest of the states, about half of the states, had no law, no statewide law, one way or the other. And I think, actually, to sort of presage the end of what I'm going to say, the U.S. Supreme Court located Lawrence right in that spot where half the states were, which was a lot of openness, a lot of silence, and a lot of uncertainty. Not about sodomy laws. Those were clearly unconstitutional, but about the status of lesbian and gay Americans. Culturally, I think another incredibly important shift had happened. If you read the decision in Hardwick, the court, it's really a very hateful decision. I mean, it's a decision that is just saturated in contempt for lesbian and gay people. A decision from the U.S. Supreme Court with that kind of language, I think, contributed to the reasons why that decision became such an embarrassment for the U.S. Supreme Court. And part of that is really a sense, because Georgia, ironically, the statute that was there back in '86, that statute covered everyone. It didn't just prohibit sexual conduct between persons of the same sex. It prohibited the same kinds of conduct between different sex couples as well. But the U.S. Supreme Court treated it and talked about it as if it were a gay-only statute. And it's really clear when you think about the language of that and the way the court conceptualized it, that that court saw that conduct when engaged in by a same-sex couple as being something different. I mean, like different. It was a different thing. It was a different reality. It was a different universe than the same conduct engaged in by a different sex couple. And I think one of the most important sort of cultural shifts that happened between 1986 and 2003, which manifests itself, not with any, explicit description in the opinion, but manifests itself in the opinion and in the culture more broadly, is a sense that it's not different. It's the same conduct. You can't penalize two people for engaging in conduct X and have it be perfectly lawful for two other people to engage in the same conduct X. And that's really the sort of structure, in large part, both of Justice O'Connor's concurrence in Lawrence and also of Justice Stevens' dissent in Hardwick. And it's very important, I think, to read the Stevens dissent. The Blackmun dissent in Hardwick got all the attention at the time, but it was the Stevens dissent, I think, that turned out to be ultimately more significant. And that cultural change, I think, explains why the language of Lawrence, although it's frustratingly, sort of amorphous and vague, why the language of Lawrence was framed as it was, in talking about respect for gay people, respect for their lives, their choices, their right to dignity, and so forth. So I'd like to sort of do, for a moment, the opposite of what Paul did. Paul said, what if we had lost Lawrence? What would have happened? I'd like to just for a second say, well, what if we had won Hardwick? How would we have won Hardwick? Well, I think we would have won Hardwick in some sense on the same, kind of doctrinal holding, a substantive due process, right to privacy, the states cannot criminalize behavior. But I think the language of that victory in Hardwick would have been about, this is pretty disgusting stuff, but we have to draw these bounds between what the government can do and what the government can criminalize and what has to be within a zone of privacy and shielded from government intrusion. And the idea of shielding from government intrusion is certainly there in the Lawrence decision, but that other part is not. And that other sort of rhetoric of privacy as being consistent with moral condemnation was very much part of the times in 1986 and is quite absent from the majority opinion in Lawrence. So I think those changes, as reflected in Lawrence, are incredibly important. Now, the frustrations, as both Susan and Dale have alluded to, of Lawrence come from the language in a doctrinal sense and the absence of any specific constitutional standard that lower courts can easily hang their hat on. I'm one of the people, I think, in Dale's second category who wrote that I think what the court was doing, and I think one of the things we have to do is to not think of it as being just about lesbian and gay rights law. I think in general the court is moving away from an investment in fundamental rights and in strict levels of scrutiny. There may be state courts that move in that direction, but I think the federal courts are moving in the opposite direction, and you see that, for example, in the abortion cases, certainly. So I think that the refusal to specify, the doctrinal refusal to specify in the Lawrence decision was intentional. I think that it was a silence that was both expressive and instrumental. I think it was expressive in the sense that it reflected a degree of uncertainty, of evolution that is not really any different now than it was 5 years ago in terms of the culture's view of gay people. And I think it was also instrumental because I think the court there, as the court did in Romer, tried to leave the maximum amount of space for the political branches as well as the judiciary to work out the tensions and the frictions between competing rights as they will sort of make themselves manifest in future litigation. And in that sense, I would suggest that although we are here to celebrate Lawrence, and I'm really happy to celebrate Lawrence, that in some ways I think Romer, in looking back, Romer was a decision a few years before Lawrence, that Romer may turn out to be, in some sense, and I'll be provocative in this way, sort of the more important decision in some respects. Lawrence was incredibly important because it reversed Hardwick, and if we hadn't reversed Hardwick, I mean, that was just essential. One cannot overstate the importance of that. But it was Romer where the court struck down a state constitutional amendment in Colorado that really indicated that the court was open to protecting the rights of lesbian and gay people. And Romer actually did lead to a number of cases in the intervening years after Romer, before Lawrence, mostly district court cases, but we won some school teacher cases, we won some harassment cases. We won a number of cases where the lower courts cited Romer, which was also completely amorphous in terms of constitutional standards, not accidentally written by the same Justice Kennedy. So just a couple of words, in a sense, about meaning. I mean, speaking personally, I was thrilled. I was there when Paul argued it. He did a fabulous job of arguing it. I was very moved by the language in Lawrence, although it has since turned out to frustrate many of us. And the way that I felt was as if I had become a naturalized citizen. That in some sense it was it was a citizenship of mine, sort of citizenship right that was recognized, even though I was born in the United States. So and in my view, at least, the language of the decision lends itself to a sense of kind of fundamentally being at the table, being sort of part of a legitimate political and social order. Beyond that, I don't think Lawrence goes very far. And I don't think that Justice Kennedy, at least, intended it to go very far. I think that what he intended, and I'm sure there were members of the majority that would have much preferred to have it be stronger in the sense of being more specific. But I think that what he intended was, as I said, both expressive and instrumental silence and openness. And the last point I will just close with is that in these contests over meaning of Lawrence, which will go on for a while, I think it's a really good lesson for law students especially, that the meaning of a judicial decision is a process. It is not something that you can nail down, that articulating the meaning of Lawrence versus Texas is very much something that is going on, that it will continue, and that meaning, what it meant the day it was decided, according to Newsweek and any number of other people, what it means today, what it means 10 years from now, will all be different. Thank you.
Thank you, Ann. Bill.
Tony. I also wanted to start out as the sort of primary Emory person on what we might call the Local Arrangements Committee working on organizing this conference. I wanted to make sure that we recognize again and again Judy O'Kelly at Lambda Legal, Liz Seaton at the American Constitution Society, and perhaps in some ways most importantly, the Emory operations staff, whom I've been working with closely to make this happen. I was saying earlier that I think Judy, Liz, and I may have set a whole new record for number of emails exchanged on Wednesday as we were frantically making sure that we had all the details done then. It was really a pleasure to work with all of these people in putting this together, and I'm thrilled to be here with such a distinguished panel. It kind of makes me look bad because I'm clearly, at the bottom, not just chronologically here, but, hey, I can work my way up. At the 50th anniversary of Brown versus Board of Education, there were those observers who noted that despite the end of de jure segregation in the American public school system, many, many African-American children in the United States continue to attend public schools that are essentially de facto segregated, and that such schools are disproportionately likely to have very poor educational outcomes. Now, you might wonder why, if we're here to talk about Lawrence versus Texas, am I talking about Brown versus Board of Education? Well, partly because, as you may recall, several people said this, lots of people said it, including a very distinguished constitutional law scholar whom I won't name, said that Lawrence versus Texas was the Brown versus Board of Education of the LGBT civil rights movement. Now, to some extent, it seems to me that even if we go with Dale's tripartite scheme here, that's just a wildly overblown claim. And I just was really, I thought it was kind of puzzling at the time. But it does provide a very interesting sort of jumping off point, at least for me. And I say that, and I want to mix into my remarks a plug for the importance of history. I got my PhD in history before I went to law school, and so I was a historian first and a lawyer second, at least chronologically. And, Dale's right that the historical analysis in Lawrence was not sufficient by itself in order to do the work that we're glad Lawrence did. But I would say it was necessary in some sense, because if you look back, Bowers is a very historical decision, right? I mean, it has these honkin' big long footnotes in it about how every state, by God, prohibited sodomy at the ratification of the Constitution. The history was bad, but it was there, and people knew it was bad at the time, but I think that, I actually think it's extremely important that, and apparently, Justice Kennedy thought it was important too. I mean, when have you ever seen a Supreme Court opinion that had such an extended discussion of a historical argument? And not just any historical argument, but an arcane historical argument about the historical specificity of homosexual identity, right? I mean, I wrote an entire book on this in my dissertation, but I was quite convinced that I was one of 12 people on the entire planet who really cared about any of this. And now here it is in a Supreme Court opinion. So I guess I would say that clearly it seems to me the historical component of the Lawrence opinion was really, was necessary, again, if not sufficient by any stretch of the imagination. So I wanted to put in a plug for history in that sense, but I think it's actually much more important for us in some sense to go back to this analogy to Brown versus Board of Education, right? And I want to, again, somewhat perhaps provocatively ask the question, 45 years from now, if any of us in this room is still alive, will we look back 50 years later at Lawrence and say, well, what really happened with Lawrence? You know, it was kind of a, everybody was all head up about it when it came down. Did it really do anything after 50 part of the reason why I want to say that is because I think sometimes these days, especially those of you who don't live in the South, there's a tendency to forget that the response of white Southerners to school desegregation was massive resistance, right? I mean, that's the standard term that every historian uses to describe it. And at first it was really overt, but massive resistance to school desegregation, but it gradually became more and more sort of subtle. I'm teaching a class on racial integration and American education this semester, and I just had my students read a really fascinating article about white flight academies in Mississippi, right? Ultimately, what white Southerners did to keep their children from going to school with black people was they just created their own private schools, which obviously also significantly undermines their willingness to support public schools for black people. Obviously, Lawrence, in some sense, in terms of its impact on sodomy laws, was self-enforcing in a way that Brown never was. I want to very, very respectfully and almost sheepishly disagree a little bit with what Paul Smith said about this, because I think he's absolutely right that the public was ahead of the courts with respect to sodomy laws per se. I really do believe, I agree with him 100%, that I don't think most of the public thought sodomy laws were particularly intelligent things. But I think we need to remember that the broad middle of the public also didn't really care very much, okay? And I very much appreciated Tony Verona telling us about listening to Rush Limbaugh and the fact that so many of his callers disagreed with him about the wisdom of Lawrence. But I also think we need to remember, and I'm real big on paying attention to conservatives because they have an enormous impact in the United States, right? I remember that the second group of Americans to land here was Puritans, and there's a sense in which there's still a major strain of Puritanism lurking in American culture. So I don't think we should focus our attention on what the broad public in the middle thinks about this. I think we should focus our attention on what people like Jay Sekulow at the American Council of Law and Justice think about it. You know, Tony was joking about how a chapter on lesbian and gay rights in the Carter and Reagan administrations must have been really short. Well, actually, I was dumbfounded the first time I went into the Carter library. Gobs of material on lesbian and gay rights. Carter actually did a lot of stuff on lesbian and gay rights. And then I found a letter in the Reagan library from Jeff Levy, who was executive director of the National Gay Task Force at the time, requesting a meeting with somebody on the Reagan White House staff. And there's literally a handwritten note that says, any meeting with this group is pointless. Would you please find a polite way to say that? Okay? So it matters, right? I mean, it really matters who we're talking to at the federal level. So I guess what I would say about this is that it's not the broad middle that we need to pay attention to, it's the conservatives. And conservatives, of course, are really, really good at getting political power even when they don't really deserve it, right? I mean, we have a conservative president who stole 2 presidential elections, right? And has been, and he, like Ronald Reagan, has been assiduous about appointing conservative judges to the federal district courts. And so, as Dale has suggested, federal judges are really good at finding stupid reasons for upholding bad laws, and they aren't going to hesitate to do it. So, and they're the ones who are going to be making these decisions, at least with respect to litigation. Now, of course, I'm also a big fan of reminding us that we're not going to solve all of our problems through litigation, that the litigation is only as good as the underlying law. And so in addition to, it is certainly, Lambda is a marvelous organization, and I think that they do extremely good work, but we also need to remember that we need to continue our political movement as well as our litigation movement. And I just wanted to close with a kind of an image that occurred to me with respect to the massive resistance issue in terms of school desegregation, but also when I was in Wisconsin, there was a spate of pharmacists refusing to fill prescriptions for contraceptives because they were conservative Catholics who considered contraceptive use immoral, right? Now, pharmacists are relatively easy to spank. They have to have state registration. You don't have any right to be a pharmacist. But what would we do if, after a U.S. Supreme Court opinion striking down all legislation prohibiting recognition of same-sex marriages, if individual county clerks in places like Georgia and Mississippi still refuse to give marriage licenses to same-sex couples, okay? I don't think that that's at all an outlandish sort of possibility, and so it goes back to what Susan was saying. No, Lawrence definitely didn't put Lambda out of business, and I'm not even persuaded necessarily that a decision on behalf of same-sex marriage from the U.S. Supreme Court is going to put Lambda out of business, because there's still going to be a whole lot of work to do. Thank you.
Bill, thank you so much. Paul, I wanted to give you an opportunity to respond to, do you not want to take one now, or maybe later, after there's been more interpanelist discussion? I wanted to give an opportunity to Susan and Dale to respond to any of the threads brought up by Nan and Bill in their third and fourth presentations.
Nan and I actually were on a panel at the University of Minnesota shortly after Lawrence came down. This was in must have been September of 2003, before any other decisions had come down. I think it was even before Goodridge, slightly before Goodridge. So what Lawrence meant was very much up in the air. And I remember that she said at the time that the process of deciding what a case means is a process, that it isn't a static, that it changes over time. And I think certainly what's happened with Lawrence since then is correct. It shows that she's correct. There's been a process, but unfortunately, a couple of things about that. One, I think that that judicial craft ought to require at least some minimal levels of clarity from a court about what it's doing. And I just don't think that threshold was met in Lawrence versus Texas, which is why we have gotten the reaction that we've gotten, in part because while there were three different strands, and I certainly think that the best understanding of Lawrence is a fundamental rights decision, I can't say that the other views of Lawrence, whether it's Nan Hunter's view of a sliding scale or Randy Barnett's view of a libertarian opinion or Justice Scalia's view that it's a rational basis decision, I can't say that any of those opinions are implausible or unreasonable. They're reasonable interpretations of the opinion. The problem is that given the composition of the federal judiciary, which I don't see as changing dramatically, even in the next administration, perhaps not for quite a long time, unless the lower courts are given marching orders on the issue of gay rights to a much greater extent than they were given in Lawrence versus Texas, they're not going to march forward for gay rights. They're going to march backwards and sideways and through all kinds of meandering. So I think that the court owed us more than it gave us in Lawrence versus Texas, although it's at the same time true that deciding what a case means is a process of interpretation. Over time, I would have thought about the next issues that are coming up that are debatable. Some things should not, I think, have been debatable. I would also say that I agree, I think, fully with Bill that the historical portion of the opinion in Bowers versus Hardwick was necessary. It needed to be there, but not sufficient. I think we're in full agreement on that point.
Now, Nan opened the door for us to speaking about Romer and the equal protection analysis there. Justice O'Connor's concurring opinion in Lawrence presented really the only equal protection argument in the case, but she obviously has left the court. Will her opinion, Nan, be influential, or is it really something that needs to be just chalked up as merely an intellectual maneuver on her part in order to avoid too stark of a reversal, considering that she had voted with the majority in Bowers? Going forward, do you think it's going to carry any more currency?
Well, I hope it does, because in part because of what Dale just said. And what I think O'Connor was doing in her concurrence, aside from avoiding having to reverse herself, is I think that she was trying to give a little bit more specificity and a little bit more teeth to Romer. I mean, it was really it was a concurrence that built on Romer because it was an equal protection analysis. And it was, I give her a lot of credit for her intellectual honesty in saying, yeah, this is heightened rational basis. This is not regular rational basis. And she there was speaking to equal protection doctrine rather than to substantive due process doctrine. But I think that future litigation, future cases in this area are at least as likely, especially because the interpretation of Lawrence so far has been largely a libertarian interpretation, a sort of autonomy as a libertarian concept in terms of freedom from government intrusion. And certainly so long as that continues, I think that future doctrinal development is, I would say, more likely to be along the path of equal protection, or at least along the path of a concept of equal liberty. And I think that, so I think that O'Connor's opinion, it's hard to say sort of how influential it will be if she were still on the court, which God knows I wish she were. If she were still on the court, I think there's a very good chance that this opinion of hers, like so many of her opinions, even when she was the sole author, really migrated to take center stage and become the controlling sort of doctrinal center of gravity in a number of areas. With her off the court, I don't know. But if I were a lower federal court judge looking to interpret Romer, I would, I think that her opinion spells it out at least a little bit, gives it a little bit more meatiness, and at least provides a platform that a judge could use to build an equal protection analysis on.
Very interesting. Anyone else?
Yeah, I mean, I'd say a couple things about that. Well, first of all, I think in a lot of the cases that have dealt with some of these core issues in the past 5 years, I'm thinking a lot of the marriage cases, the organizations like ours have very carefully stayed out of federal court and have used state constitutional arguments while trying to use Lawrence and Romer as kind of baselines for the state constitutional analyses, with very mixed results. I mean, we get really good, we've gotten some really good trial court decisions, some really good dissents. There's Goodridge, which I think, quite rightly it's not clear that it is endorsing Lawrence as a fundamental rights case calling for heightened scrutiny. In fact, I think Goodridge is an example of a court breaking free of a sort of categorical and tiered approach. So, I mean, first of all, I think that we're going to have to look and see what's happening over time in state courts. I think a lot of litigators like us are reluctant to try to rock it up to the U.S. Supreme Court. I mean, there are the don't ask, don't tell challenges, but, I do think there's some reluctance to press too hard, too fast right now. I do think, though, as you pointed out, Nan, Justice O'Connor's concurrence on equal protection really was building off Romer, which she did not write. And the majority, the 5 who voted in the majority in Lawrence are still there. So there's, I think there's still a lot of hope that it actually wasn't O'Connor in the first place who developed this sort of heightened rational review concept. But the other thing is, just again from like the slogging litigator's perspective, it is, I have to admit, extremely frustrating as like the lawyer has to write the brief and argue it in court. I mean, it's fascinating and I think quite tapping something really real to say that the court is shifting and moving and that old tiers don't necessarily work so well, but. Paul had talked about the Lofton opinions, and I went back also to look at them, and Judge Birch wrote in his sort of what he wrote about why he thinks they were absolutely right not to take the case en banc and reverse themselves is, you know, when Supreme Court decisions establish new rules of constitutional law, they are accompanied with clear guideposts for applying the new rule. Lawrence does not appear to be such a case. We find in the opinion no such guideposts. There is no description of the scope of this putative fundamental right, no standard of review for scrutinizing infringements on the right, no balancing test, and so on. And, you know, again, I just feel like there is really some justice to be, you know, to the idea that if it is not tied up with a ribbon and handed to lower court judges and also certainly state court judges, we find ourselves in like the litigator's dilemma.
Dale.
Yeah, if the lower courts had been favorable to gay rights, poetry would have been enough in Lawrence versus Texas. But
So true.
But poetry wasn't enough, and they needed marching orders. I agree with both Nan and with Susan that equal protection may be the more fertile ground for gay rights claims in the future. Remember that one thing that the majority opinion said in Lawrence is that it did not reject Justice O'Connor's argument. In fact, the majority said that equal protection arguments were tenable. That was a signal, at least, that this might be an area where gay rights litigants can move in the future. And in fact, as I read Justice O'Connor's concurring opinion in the case, it's actually a blending of substantive due process concerns about intimacy with standard equal protection doctrine. So it's some blending of the two might be possible in the future, and we may come to see at some future date both Romer versus Evans and Lawrence versus Texas as sort of the Reed versus Reed and Frontiero in sex discrimination for the gay rights movement, but I think that's a number of years off. I should say that I actually submitted an amicus brief arguing for a result based on equal protection, and the Supreme Court cited, I think, just about every amicus brief in its opinion, except, of course, the one I wrote. So I'm especially disappointed that Justice O'Connor didn't prevail.
Bill?
I think a couple of things about that, one of which is that I think we need to remember that, especially in controversial decisions like this, there's a substantial political component to what the Supreme Court does, and I think part of what's going on here is that I think Kennedy really wanted to strike down sodomy statutes. I mean, he's really emphatic about how he thought Bowers was wrongly decided in the first place, but he wanted to do it in a way that was sort of politically careful, right? I mean, and I think that's why both he and O'Connor explicitly sort of suggested that, in fact, their opinions would not reach to same-sex marriage, even though, you know, Scalia's right. I mean, it's kind of silly for them to say that, but legally. But I also think it's interesting to me when I look at, the other thing, you know, Kennedy also explicitly says, right, that there's a connection between due process and equal protection, right? And, of course, he's right about that. So he not only says the equal protection argument is tenable, but he also says you can't really completely peel the equal protection argument off from the due process argument, that they're closely related, which is, I mean, I think is exactly right. I think it's also interesting to look in O'Connor's concurrence at the cases that she cites. And I haven't actually, like, sat down and counted, but I believe that the case that she cites most frequently is Claiborne versus Claiborne Living Center, okay? Now, that's an interesting case because there the court specifically refused, right, to find that mentally retarded people qualify for suspect status under the court's equal protection jurisprudence, but they still struck the law down, right, or the application of the law in the case of Claiborne. And it's fascinating to me because that's exactly pretty much what happened in Romer, right? I mean, the court did not explicitly consider whether or not queers are a quasi-suspect or suspect classification. In fact, as several people have pointed out, that's completely absent from the decision. But at the same time, I mean, without doing any of that, Kennedy still said, well, rational basis is sufficient to strike this law down. Now, if I were arguing before an equal protection case on an LGBT issue before the Supreme Court, I would certainly put in my brief that I believe that sexual orientation should be a suspect classification. At the same time, I have to wonder, in some ways, are we not better off getting what we want via rational basis? Because there is that way in which when the court does strike something down under rational basis, it's kind of a bitch slap, right? I mean, it's like saying, duh, this is obviously not a valid form of legislation under our constitutional framework. And in some senses, I think with Amendment 2, that was a really good thing. So.
One last question before we go to Paul to see if he has any thoughts in reply. What might the fate of Lawrence be under President McCain, should he be inaugurated next January? And would it be any different from fate under a President Obama or President Clinton II? Anybody?
Do you mean like for reversal of it, or if it were to be decided? I mean, God
Progeny,
forbid.
anything?
Well,
Yeah, I don't think that I don't think the courts. I mean, I think as a lot of people pointed out. First of all, Lawrence's time was long overdue, frankly. So the idea that the court would say, and the vehicle, it's hard to imagine the actual vehicle for getting the question up there. I could see the court kind of, I hope not, but I guess the worst case scenario would be a change in the justices and some other kind of case getting up there where there's a clarification. Like we really meant an incredibly narrow thing in some other kind of, substantive due process context or equal protection context. But I'm not prepared to wrap my mind around that.
But see, I think what our discussion has demonstrated is that really, I don't think the concern is whether or not somebody's going to try to overturn Lawrence. I think it's what federal judges are going to do with
at the
Lawrence.
lower level. Yeah.
That's the issue.
Yeah.
And I think Dale's right. We're not going to see a wholesale change in the composition of the federal judiciary anytime soon, just because there are so many federal judges, and it takes a while. And, of course, we all know they have lifetime tenure. But, and this goes back to my point about the importance of politics, right? The only way to do it is to get a president who is more sympathetic to our issues elected, and I think either of the Democrats will do a fine job. There's Pinello, P-I-N-E-L-L-O, is a political scientist who wrote a book called Gay Rights in American Law, and he claims, at least, that he literally managed to accumulate every appellate decision addressing lesbian and gay rights in the entire country. And he demonstrates statistically, folks, your identity as a federal judge has an impact on how you respond to lesbian and gay rights decisions. It just does, empirically, okay? With younger and female and racial and ethnic minority judges more likely to be sympathetic to lesbian and gay rights claims than older, whiter, maler judges. And I think that there are a lot of really good reasons for us to have a lot more women and racial and ethnic minorities on the federal bench, right? I mean, lesbian gay rights is by far the only reason to support that. But I strongly suspect, I mean, I would be really surprised if either Hillary Clinton or Barack Obama did not make a point to try to find more racial and ethnic minorities and more women to put onto the federal bench, and that's not going to be much. I mean, McCain might appoint more women, but they would probably not be women who would support our positions. And so, yeah, I think that's the huge difference right there.
Other thoughts, Nan?
Well, I agree that it's really, I can't imagine the Supreme Court reversing Lawrence. It is true that, in the aftermath of Lawrence, unlike Roe, for example, where the sort of the demand and the sort of slogan is reverse Roe versus Wade, there's no, nobody cares about reversing Lawrence. I mean, nobody demands that. No marches, nothing. I mean, the issue of marriage has really sort of filled that political space. And I actually think that's why, Scalia, one of the reasons, it was fascinating to me. I mean, when in the days before Lawrence was announced, it was more the sort of Rick Santorum nonsense about how the slippery slope, if this is permitted, then anything will be permitted. And as soon as Scalia's dissent focusing on marriage kind of took hold, and of course I think that summer, that period of time, there was also a Canadian decision, and Goodrich wasn't too much longer. Marriage just really filled all that space, all that political space. So I think the question is not about reversing Lawrence. I do think the Supreme Court in the next several decades will continue to hear one way or the other, whether we want them to or not, a number of important LGBT rights cases, and even more important than that is the identity of who the judges are in the lower federal courts.
I agree. I mean, I think it's safe to predict that McCain-appointed judges will be less sympathetic on average to gay rights claims in the future and to more aggressive readings of Lawrence than either Obama-appointed judges or Clinton-appointed judges, and there's a lot of empirical data to support that, that prediction. It may not be as bad as some people think, because if my political reading of this election is correct, even if McCain wins, we're very likely to have a Democratic Senate, and maybe even, this would be an odd result, but and almost unprecedented, but maybe even a strengthened majority, Democratic majority in the Senate. So while that's not going to make the judges wild-eyed gay rights activists, it is probably going to have at least some moderating effect on what they would be if we were confronted with a Republican-controlled Senate.
Paul. Oh, Susan, you were going to say.
I'm sorry, Paul. Just a little. I just want, when I feel like I don't mean to sound like too much of a downer, because I do think it's also important to. I think in some ways it hasn't mattered, and it shouldn't matter dramatically who necessarily are the judges, because I think there's been a tremendous amount of progress that's been made in the past 5 years, built on progress made before, and I think Lawrence sped that progress of, things that are happening in legislatures around the country, things that are happening as a cultural matter. I mean, in just the last 5 years, John Davidson will talk more about this, but there's been so many more formally recognized relationship protections in a number of states around the country. Civil union, domestic partnership, marriage rights, recognition of marriages in the state of New York, of out-of-state marriages, that, I do think we have to recognize that there's been some progress in the courts in applying Lawrence, and then there's also been a tremendous amount of, 2 steps forward for every step back in how the states are treating same-sex relationships.
True. Paul.
I would just add that
That mic seems to be off. Can someone please turn it on? I think we switched it on. There we go.
I'll just try to talk louder. Without disagreeing with that figuring out the meaning of a rather opaque opinion is a process, it seems to me that the ultimate end of the process is going to be a Supreme Court decision someday, not a bunch of lower court decisions. And a lot of what you guys have been talking about, the lower court is trying to wrestle with this, will be seen ultimately in historical perspective as a fair amount of static. Because someday there's going to be a Supreme Court case, and it's going to be soon, I would think, it's going to say Lawrence is either about fundamental rights or it isn't. And so like much of our constitutional jurisprudence, the ultimate meaning of Lawrence turns a great deal on what's going to happen this November, because we are on the precipice, it seems to me, of either going one direction or the other. And I think we tend to underestimate how far to the right the court will go if they get one more member. The 4 are really quite stalwart. And so the scenario, it seems to me, in that situation is a decision fairly quickly, essentially saying Lawrence is a one-time, a one-trick pony. That's all it's going to do is get rid of sodomy laws, and that would be the minimum they'll do with it if they get another vote for the Scalia wing of the court. On the other hand, it's a great opportunity to, if they have a court that wants to take what the court said there and make it into a much broader, more meaningful decision. I mean, as Justice Scalia himself pointed out, the logic does lead you in the direction of relationship recognition, for sure. But boy, the I may be more pessimistic than some about the downside if the election goes the wrong way, because Maybe they won't have a case to overrule Lawrence immediately, but there'll be abortion cases, and there'll be cases about whether there really even is a substantive due process doctrine. And my view of these guys is that they are really willing to take on very fundamental issues and rethink doctrines that have been around for decades, and we could see a revolution in the law. And once Roe v. Wade goes, how quickly is the logic of Lawrence going to be undermined in the court? So it's a very interesting time politically and constitutionally, because things will either go very well or very badly, it seems to me, in the next 10 years, and a lot depends on just this year. So that's what I would add, my 2 cents.
Any reaction from the panel before we go to questions from the audience? Questions from the audience. We have a good chunk of time, about 20 minutes or so. Yes, sir.
Paul, when you talk about Roe versus Wade versus Hardwick and Bowers, if Roe versus Wade gets decided differently, nobody has abortions, and people keep getting arrested for being abortionists and for seeking abortions. But Bowers and Hardwick, which started right here in Atlanta, about 2-3 miles from here, it's not like after that decision the cops knew that it was all right for them to start running around into people's bedrooms. There wasn't this huge rash of, you're all talking so polite, but nobody was, getting arrested in their bedroom for going down on anybody. The Bowers, the thing that to me is so amazing about this is that Bowers versus Hardwick was about a sodomy law that applied equally to same-sex and non-same-sex couples. And yet it was seen as, if the headline had said gays lose, that's all it had to say, gays lose. Since then, and in fact before then, the last 2 times anybody in this state did time for violating the sodomy law, and I'm not talking about solicitation in a park, but for going down on somebody, it was a man who'd had oral sex with a woman. In one case, his wife. And it was, that was what was happening in the Powell versus State case. That was a guy who had sex with a woman. And then we come along to Lawrence versus Texas, and again, the Supreme Court is talking about the decision it made was a decision on laws that would have treated same-sex and non-same-sex couples equally. And the headline the next day could have said, gays win. And it seems to me it was almost like waving a flag. The gays didn't really win, other than that's what the headline writers, that was a spin everybody put on it. For gays to win, Lawrence versus Texas had to be Justice O'Connor's decision. And if Justice O'Connor's decision comes out of Romer versus Evans, and if Romer versus Evans was written by Justice Kennedy, then why the hell couldn't Justice Kennedy have been the one who wrote Justice O'Connor's concurrence? That's what I don't understand. And I can't believe that everybody who signed on to the Kennedy majority wouldn't have signed on to the Justice O'Connor decision. And then you have a gays win decision.
Thanks very much. Nam?
I just want to respond briefly to that, because the impact of Bowers versus Hardwick, you're right, and I think I said also that the Georgia law applied to everyone, not just gay people, but it was interpreted and enforced, and it had a social meaning, if not a legal meaning, that I think justified the imprecision and incorrectness of the headline that said that gays lose. So that the kinds of laws, whether they covered only gay people or straight people also, were used against gay people in custody proceedings and employment of police officers, and a number of other contexts. Even at some point, professional licensing for attorneys. And so it was really the social use of those laws that was important.
Can I also, yeah, I mean, I think Nan mentioned custody decisions as an important area where judges would use sodomy statutes against lesbian and gay litigants. I also think that we need to appreciate just the generalized psychological impact, and I think that's exactly what, actually, I was really impressed at one level with Kennedy, where he trotted out what Scalia denounced as the famed sweet mystery of life passage, right? The sodomy laws actually have an impact on people's perception of their own sort of capacity for political participation, and I was especially interested to hear Susan's story from Arkansas about the guy who would not report an assault for fear that he himself would be branded a criminal because he was associated with sodomy, okay? So that means it doesn't matter whether you get arrested or not for sodomy. It matters whether or not you perceive yourself as falling into this criminal class and then conclude that that should impair your ability to participate actively in the political process. And I can tell you, after doing 10 years of lesbian and gay civil rights work in Tennessee, which had a sodomy statute for most of the time that I was there, most queers in Tennessee are not very politically effective people. And there are a lot of different reasons for that, undoubtedly. And the sodomy law did go away, thanks to John Davidson's predecessor, Abby Rubenfeld, who lives in Nashville. But the stigma and the psychological impact is not going to go away immediately. It's just not.
Mm-hmm. Susan?
Sure.
And then Dale.
Okay. And I think that, I'm of the opinion that Justice Kennedy's opinion was fabulous, far-reaching, that he was actually, even if one might look back and say, in an inexpressive way, was expressing a recognition of a very core liberty interest that can't be infringed without even a legitimate government interest. Moral disapproval is not it. It goes very far. I think it's not been correctly applied by a number of courts. But what Justice Kennedy did really was a big win for lesbian and gay people. And I think that it was important that his opinion was very important in saying we are overruling Bowers. I think Justice O'Connor, having been in the Bowers majority, perhaps wasn't in a position, did not feel herself comfortable doing that. The other justices who ruled in the majority did. Justice O'Connor found a way to come out the right way. But I think that also what the majority opinion was saying was, in many ways, we are also making an equality opinion here. This really is also very much a blending of equality principles, liberty. We don't dole out liberty depending on the identity of the actor. And so if everyone else has the right to privacy and autonomy in making decisions about their partners and the acts of sexual intimacy they engage in, it is no different for lesbian gay people. It is very much a sort of equal protection imbued principle. So, and the other thing is, I remember, when we first looked at the Lawrence decision, feeling like, wow, this is really fabulous because it is going to apply, even more broadly because it's enunciating a sort of core fundamental right here.
Dale.
Bowers versus Hardwick touched almost every area of life and litigation after it was decided, and the existence of sodomy laws themselves were used to justify all kinds of discrimination against gay people. There's just, the impact of Bowers was broad and deep. And so undoing Bowers versus Hardwick by itself was a tremendous victory in Lawrence versus Texas. There's no question about that. But I also want to add, I mentioned earlier I'm writing this book on Lawrence versus Texas, and one of the things that I'm doing is looking at how the sodomy law in Texas was used. And it was used, of course, in political ways to make arguments that gay people were presumptively criminal, and it was used in ancillary ways to, say, fire a lesbian from the Dallas Police Department on the grounds that we couldn't have these criminals enforcing the law and so on. But it actually turns out that one of the myths, I think, about sodomy laws in the country is that they were unenforced in themselves. That is, that they were never enforced against private, consensual, sexual activity. My own research, and I can only speak for Texas, I can't speak for the rest of the country, but my own research has uncovered several instances of enforcement of sodomy laws against private, consensual activity, which ended in arrests and ended in fines and even some short jail time, but which were not appealed or which were quickly settled because the people involved were so embarrassed about what had happened and so unwilling to challenge the laws that the cases never made it into appellate court opinions, never made it to the Supreme Court. They were quickly gotten rid of. And that's part of the underhistory of sodomy laws that is not well known in this country and should be made better known, I think.
Thank you for that thought-provoking comment and question. Yes.
I had a quick question. As a slogging law student, as it were, I found the concurring opinion by Justice Thomas in this case to be quite amusing and almost knocked me out of my chair when he basically asserted that it was an uncommonly silly thing for government to be involved in such matters. Does that indicate sort of a mellowing of our heretofore viewed conservative justice, and we possibly anticipate him being a swing justice for gay and lesbian rights in the future?
He wrote, I write separately to note that the law before the court today is, quote, is uncommonly silly, quoting Stewart's dissent in Griswold.
Well, I think what his opinion represents is that there has been a certain amount of political progress in the country about the reach of government and minimal respect and rights for gay people. When a person who is as attached to conservative philosophy as Justice Thomas can say that the Texas legislature has no business enacting laws like this, and I would vote to repeal it if it were before me as a legislator, that represents a marker, I think, of a kind of political progress in the country. But at the same time, in his very brief concurrence, Justice Thomas, as a constitutional matter, made it very clear that it's not his job as a justice to strike down very bad and uncommonly silly laws. And in fact, following up on what Paul said earlier, Justice Thomas suggested that there is no right to privacy in the Constitution, which would not only undo Lawrence versus Texas, but would undo, of course, Roe versus Wade, and even Griswold versus Connecticut.
Other questions?
While we're waiting for the next question, could I offer a point of order? I completely did not hear that last question, so when you're holding the microphone, please make sure that you're speaking into it and you still speak up. If there are any of my students in the class, they're already tired of hearing me say this, but I say it all the time. Speak up, please.
So I'm supposed to stand up too?
Yes.
Can you hear me, Professor Cronin? So there's a lot of scientific research continually going on about the source of homosexuality as far as, whether you're born with it, whether it comes from other, very early age, hormonal circumstances, whether it's a choice, things of that sort. How do those issues, you think, impact, the degree to which homosexuality is an immutable characteristic? How do those issues impact issues like Lawrence? And maybe this is a question for the next panel as well. Say there was research that came out one day that, proved definitively that homosexuality is not a choice at all. How would that kind of conclusion impact legal arguments?
Great question. Please pass the mic forward to Angela. Answers?
Yeah, okay. Well, I would argue that it should make absolutely no difference whatsoever. That I think that if in point of fact there were some sudden scientific consensus that sexual orientation had no component of agency, that there was this dichotomous world, that there really no one is bisexual, that it's all something that's very hardwired. I think that would make it easier politically, at least in the short term, because people can't help it. It's like there was this roulette and they lost, right? And they turned out gay, and I think that's how the culture experiences it. I think it's much more important to argue that it should make absolutely no difference, that different people experience it different ways. Different people experience different degrees of agency, which is not to say that it's like picking an ice cream flavor. But people just have different life experiences, and I think it should be thought of more as something that is very much related to a kind of liberty of belief and conscience and choice of destiny, to actually use some of the language in Lawrence. People often make the comparison to religion. People switch religions. It shouldn't be held against you if you do, even if most people don't. So I think the most important argument to make is, regardless of what the science ultimately turns out to tell us, and I have no idea what it will, it should make no difference.
Susan.
Yeah, and I completely agree with Nan. I'll say I think where we see it come up in the litigation, it has been mostly when we are arguing for heightened scrutiny, in a tiered equal protection approach. And again, like the litigator's dilemma is that we don't think it should matter at all, and that is what we argue, but then we sort of go on to make sure there's the brief there that kind of marshals a bunch of the social science for the judge who just can't get beyond this point. But I also think Lawrence helps a lot in making it a far less relevant thought in anybody's mind as a legal proposition, because I think what Lawrence really does say is it's your, you have the liberty to make these choices for yourself, and doesn't ask where the source of your interest in that choice comes from.
Great.
I have a very strong opinion about this, because I think that all LGBT rights supporters should respond to the, oh, is it a choice argument by saying, doesn't matter. And I reemphasize that point, even though Nan and Susan just made it, because I think that it has more, Susan was just saying, it's in a certain sense, in the litigation, it's not that big of an issue. It's more of an issue in the political debate, right? Because there are all those people out there who somehow believe that immutability is a necessary characteristic for civil rights protections. Well, according to that logic, then that means that we prohibited racial discrimination because black people can't change to white people. That's not why we prohibited racial discrimination. We prohibit racial discrimination because it's bad and wrong, right? And I think one of the things that we should try to work on here, politically especially, is to move the focus, really, in the lesbian gay rights debate away from lesbians and gay men and toward the conservatives who want to discriminate. Because the point is, they're the ones who are violating the fundamental principles of American law, right? I'm just demanding anti-discrimination. I'm just doing the same thing Thomas Jefferson did when he flipped off the king, okay? And so as far as I'm concerned, I occupy the moral high ground, and conservatives have done an extremely good job of using the whole is it a choice issue to distract from the real issue, which is discrimination.
Now, prior to my having you ask your question, Angela, I'd like to see if anyone else has a question so that we could ask them sequentially in our last 7 minutes and then have a group response to all of the questions at the same time. So please raise your hand to let me see if there's anyone else. Okay. So Angela, ask your question, and then there's one more.
Can I just respond to this one real quick? Doctrinally, under the equal protection doctrine that the court has developed over time, immutability matters except when it doesn't. The immutability has been mentioned in a few plurality opinions, but the court has never said that it's absolutely required for suspect classification, for heightened scrutiny of classifications directed at a group. It's helpful doctrinally, but it's not, and I agree with the others, should not be required.
Angela.
My question goes to if Lawrence, part of the silence was to create this political space, as you talked about, what piece of federal legislation would do the most good in giving Lawrence more legs in the federal courts? And I say this sort of after watching the California marriage oral argument and obviously the Goodridge opinion, which rested on a lot of legislative work that had been done, particularly in the area of child custody adoption, which obviously are state level decisions. But in terms of the federal level, if you had your choice, and we are in this position to have a president to sign a bill, which piece of federal legislation I think would do the best for the community, repealing part of DOMA and Don't Ask, Don't Tell?
That's a great question. Would you please ask yours too? There's a mic right there you could speak into if you wish.
I would never want to downplay the work of Paul Smith, but just to
I'm sorry, I can't hear you.
Sorry, can you hear me now? I'm on testing Verizon. Can you hear me now? In considering the two different cases of Bowers versus Hardwick and its later reversal in the Lawrence decision, how much do you think the sympathy factor played in terms of the judgment of the justices involved? When we look at Hardwick, he's basically spoiling for a fight. He calls someone up and says, hey, I'm about to have sex, come arrest me. The plaintiffs in the Lawrence decision, or the defendants, I'm sorry, were not necessarily spoiling for a fight. They were viewed more as the victims of government intervention, more so than calling up the police and kind of saying, here I am, come and get me, if you really want to make a big deal about this. Do you think any of that played a role in terms of the outcomes of the decisions, or totally moot point?
Great questions. Thank you.
Two very different questions. I'll take the second one first. I don't think Michael Hardwick called the police and said, bring it on. I think he had been involved in some altercations with the police, actually involving police harassment, in part involving police harassment of a gay bar. I think from both of those cases, although of course one always wants to choose one's clients and parties carefully and so forth, I think the issues dominated the people in terms of what the particular facts were in either of those cases. With regard to your question, federal legislation, I'd have to say I think that passage of a sort of good, strong, rich INDA, if you're limiting it to sort of legislative proposals that have been on the table, in a sense, right? Well, I mean that's a realistic thing to do, right? I could say we should have the full 1964 Civil Rights Act or whatever, and that would be better, and you could come up with something else better. But in terms of anything that's even remotely possible in the next few years, I would say an INDA for LGBT Americans would be the strongest message that Congress could send.
I actually, I think I'm torn. I would be torn if you asked me what was the top of my legislative agenda between repealing the section of DOMA that refuses to grant federal benefits to same-sex couples when they're recognized in their home states, because I think relationship recognition is part of the heart of the Lawrence decision. And I think those benefits are very important to people. The other would be repeal of Don't Ask, Don't Tell. One of the markers of full citizenship in our country is the ability to serve in the military. This happened with African Americans. It happened with women over time. And the integration into the military, I think, is culturally and politically very, very important, in addition to the fact that there are many people who want to serve who are being cruelly excluded and witch-hunted even now under the Don't Ask, Don't Tell policy. On the other question, I took part of it to be a comment or a question about what might have motivated the justices. And, while we like to argue about the principles in constitutional decisions as if constitutional law is autonomous, it's free-floating, independent of life, A lot happened between 1986 and 2003, and one of the things that happened is a lot of the justices knew actual gay people by 2003. It was possible for a sitting justice on the Supreme Court in 1986, to tell a law clerk, I never met a gay person. It wasn't really possible for a justice to say that by 2003. And that alone, aside from all of the doctrinal developments and everything else, must have had a huge impact.
Bill and Susan, last 2 minutes.
In terms of pieces of legislation, of course, I'd want to see them all passed. Don't mean to say I don't endorse it all, but I guess if I had to pick only one, I would say ENDA. I feel like it's time that people in parts of the country that aren't getting relationship recognition, aren't getting anti-discrimination laws passed, in the really underserved parts of our country, for whom Lawrence did change things in some ways, because it was a lot of those states that still had the sodomy laws. I think it's time that people had at least the security of a good, rich ENDA, whereas Section 3 of DOMA, it's got to go. But at the moment, it's not really that many people in our country who can marry anyhow, or in same-sex relationships. And I don't think that the premise of the Hardwick question, I sort of agree with Nan, but I also think that an very interesting and powerful thing about the Lawrence opinion is the respect and dignity with which the couple, the men, were treated. The court didn't seem to sort of want to question or get into the nature of, how close really were they, what really had gone on, but was very interested in cloaking them with the same sort of dignity and respect for their right to be doing whatever they were doing.
Just one little thing I would point out. I was going to say what Dale said, but Dale said it. And my basis for saying it was going to be, if you're interested in this issue, I think that there's a really effective discussion of it by Arthur Leonard, who, of course, for those of you who know, he's up there with Nan in terms of the pantheon of gods and goddesses of LGBT civil rights scholarship. And he says exactly the same thing in his chapter in the book that I edited, Creating Change. That the difference, he wrote the chapter on, from Bowers versus Hardwick to Rummer versus Evans, because the book came out before Lawrence. But he just says, flat out, how do you explain the shift from Bowers versus Hardwick to Rummer versus Evans? More justices knew more queers, which I think also takes us back around to the importance of the political movement, right? And one of the big things, when I first started doing LGBT rights work, one of the big things we always did was National Coming Out Day. Because if you don't come out of the closet, you're not going to combat stereotypes about LGBT people.
Let's take about a 15-minute or 12 to 15-minute break. Panel 2 starts right at 3:45. Please join me in thanking our fantastic panelists, Nan and Dale and Susan and Beth.